Go bold at boldip.com.
Hello out there, and welcome to the Bold Inventor Show. I'm your host, JD Houvener, with my co-host, Matt Kulseth.
What up, what up?
What's up, dude? How's your day?
Busy, man.
Yes.
Just living the trademark dream.
Oh,
No, it's going really well. Just busy, which is kind of unusual because this time of year, things tend to start to slow down a little bit, but we're still pushing. How about you?
Yeah. Busy too. It's a busy hump day. I'm working on getting over the hump. Yeah, it's a big one. A lot of meetings back to back. Just had a really fun business planning meeting though. Working up some fun things for the future.
Nice.
Here at Bold Patents and beyond. So it's very cool. So lots of good things on the horizon. In fact, one of the cool things, Megan, so her daughter just came on board.
That's so cool. I love that for us.
Yeah. So we're now multi-generational law firm, family law firm.
More Harrises, the better.
Yeah, I think so. More females, the better. My gosh, we're outnumbered.
You can't say that. You're going to get sued by someone for.
I'm not saying it.
Being a sexist against men.
Right. Oh no.
I really enjoy working with women too. In my professional career, I mean, I think I've had more positive experiences working with women than men, generally speaking.
Absolutely.
Yeah.
Well, we're here today. We're talking about not just women and men in general, but talking about intellectual property, specifically patents. And the title here, I'm reading Patent to Payday with one of our clients, Tom Stegeman. Hopefully he'll be joining here shortly. I'm going to see if there's any technical difficulties he might be having joining us. When I see him pop in backstage, we're going to want to bring him in.
I love that. Yes, we're talking about monetizing patents and trademarks, I suppose, for that matter. So
yes.
Licensing deals, that sort of thing?
Yes. Yeah, he got a licensing deal done.
Cool.
And I think he wants to be careful with how much details with regard to the actual deal. But he wants to talk about the path, how we got there, and his approach. So absolutely, Jonathan, I'm glad to hear your money tongue is out. You're ready to learn about how to make the dollars, make it rain.
Yeah,
thanks for being a part of our show. Anybody out there listening live, please don't be shy. Shout out, say hi. If you haven't subscribed yet, click the subscribe button. I'm a patent attorney. I'm JD Houvener, founder here at Bold Patents. Matt's here, our trademark attorney. And our main dude when it comes to trademarks and also UDPR and other type of domain stuff.
UDRP, Uniform Domain Resolution Procedure.
Yeah. It was one letter off.
That's all right. Yeah, no, that used to be that's like a World Intellectual Property Organization thing for like taking other people's website domains who are infringing. But I just did one last month and we won. Yes. So that was cool, but I haven't done one in years. So
okay. Well, there you go. It can be done and quite recently. So you're sharpening your.
Yeah, you can win against big companies. So that's good.
As I do share every week here, we are live. We're attorneys, but we're not talking about giving legal advice on this show. So don't share anything confidential. Our legal notice is up. By attending the broadcast, you're not becoming a client, and we're not giving you legal advice specifically. But we're talking about legal information. So we're sharing things about generics, hypotheticals. Jonathan Mitchell says, congrats to you. Pop the champagne on that win.
I appreciate it. The client was super happy. So that's always a great day.
Love it. Well, we've got some Q&A we're going to jump to right away. And like I said, hopefully we get our guest on. I will check and see while you're doing a question, I'll see if he's able to get in there. I'll give him the link again.
Sounds great.
Okay, so let's head over.
Let me at it. I'm ready. Put me in, coach.
Yes. Okay, let's go to our Reddit bucket. This one is unfiltered and just pulling it. The title is Website versus Podcast.
Yeah. Okay.
So this could be something good. Hi, can an editorial website share a name trademarked for a podcast? If not, does this mean I need to come up with an entirely different name? Or would it be okay to just adjust it enough so it's not the exact same?
Cool. This is a great question.
Okay.
And just like every good attorney answer, it really depends.
Perfect.
Right. So let's talk a little bit about podcast services versus like editorial website services. And I don't exactly know what an editorial website is. Do you have any idea what he's talking about? Like, Do you know
Well,
that?
I would say editorial website. To me, that means someone who actually edits websites. So like a WordPress maybe, or a company that.
Yeah, like maybe they build websites for folks.
Yep.
Okay.
That's my thought.
Yeah. So what's interesting is that both of these services, by two different companies with the same name, are going to be in the exact same class of services at the USPTO. So quick recap, there's 45 different classes of goods and services at the USPTO. The first 34 are products, and then 35 through 45 are going to be services. Both of these companies are going to fall into class 41, which is educational entertainment services. Well, I shouldn't say that. I was thinking that this was actually like a website that they were protecting in class 41.
Yeah, so maybe it is that, like it's a website collaboration where people come together and share information on the website.
That's tricky. So I think my answer would be no. This wouldn't be a potential problem, unless, of course, the editorial website is about editing podcasts, right? Then of course, it's going to be too close, right? Because you can have a podcast about editing podcasts and have a podcast or a editing podcast service or whatever.
Yeah.
But I think, I would say it's a big world. And so long as that there's no confusion between the parties regarding, the services that each are providing. So your podcast might be about cars and their website might be about editing websites, right? If that's the case, then there's no likelihood of confusion here, even though they're the exact same name in the exact same class.
Got it.
So the presumption would be at the USPTO that there would be an issue, and then the examining attorney would look at it and he or she would make the determination whether or not there's actually any likelihood of confusion. And I would say very likely there isn't, but if they're in any shape, form related to one another, if they're both about business, for example, or consulting services, then it's going to be a problem.
Okay. We've got the Bold Inventor podcast. Oh. If there were a website out there talking about a collection of inventors getting together and they call themselves the Bold Inventor website, you don't have a problem with that, right?
I do. That would be a problem.
Okay, because it's about inventors.
Because it's about inventors. It shares like a subset of, individuals essentially who it's geared towards or the topic's about. Okay. So, as long as those topics are going to be in different spheres, right, then we should be okay. But Bold Inventors podcast, Bold Inventors, workshop, too similar.
Love it. Great answer. Thank you, Matt.
Yeah.
Okay, let's over to the patent camp, see if we got any in the hopper. Okay. This is a tough question. I've been skipping this one every week. I'm not going to skip it this time.
I hope this one's for you, not me.
This is for me.
Yeah.
I'm thinking this is an Apple product, I'm guessing. So I'm manufacturing a product to be sold in the U.S. and like to duplicate the packaging box from another brand. The brand in question has patents on various other far more complex type of packaging, but I haven't been able to locate any for this style of box. It's basically just a chipboard box, but the style, shape, and how it's glued together is semi-unique. We duplicated the packaging by reverse engineering and unfolding the box and recreating the die cuts. So it's exactly the same. I quickly ran it by my attorney, and he doesn't think it's something they could even get a patent on since it's such a basic design. But I'd like to do more in-depth search to confirm before we go into production. Where would I even start searching? This company that has thousands of patents for various types of products. Like I said, this is my mind goes to like this.
This is definitely like an Apple product.
Anyway, so okay.
And yeah, this is more obviously a design patent question, and I can jump in on the trade dress side because this is a trade dress issue too.
Lovely. I'll do what I can on the patent side. I will say the bulletproof answer is going to be to hire a patent attorney and get a determination on freedom to operate. That is what FTO stands for. If I can stretch, there it is. Have you looked at the patents that are issued and even those that may be pending to see whether you're going to be stepping on the toes of current rights holders or future rights holders? So having that search, looking at specifically, if you know who this product maker, you can do a query, look for specific words. If it's a utility patent, but likely it's a design, so you'll be looking at design elements and shapes. So having a thorough search done is important. And if you're aware of any patents specifically, you can look element by element and get a claim chart built out. That takes money and time, right? So if you don't have any money and time, go get some more money. And you're going to be seriously, because if you go out and start making the identical or very similar box as someone else, and they've got the funds to go enforce their rights, you're going to be hit with a cease and desist and be liable for damages. So that's my short answer. Don't do it without looking. Don't do it if there's likelihood of infringement.
Yeah, change your box a little bit.
Yeah.
So I've been through this whole, box manufacturing process, custom box designs, die cutting, creating a custom die basically to stamp the boxes for the folds and all that kind of thing, and cut out the paper from the large sheets. Just edit it a little bit, make it a little bit different, make it different enough. I mean, sometimes people ask me like, oh, does it have to be like 25% different or 50% different? There's no answer to that, but I think as long as you can say that you're not directly copying the box, you have a better argument if this company did come after you.
Yes.
But I think, no, your answer is great, JD. I think it depends, right? It depends on whether or not they have a design patent on the box.
Yes.
Depends if they have trade dress registration on the box.
Yep.
Trade dress protects the look and the feel of something without any utility, kind of similar to design patents. But Apple does love to file. Large companies love to file design patents or design trademarks for trade dress. So,
I think they can do more with it. That's sort of the unfolded form, right? Or I think they can do more with trade dress. With a design patent, you're limited to a final fixed form.
Got it.
So, in terms of, it does in general cover scaling up, scaling down. So we just made it larger. You're still infringing in terms of the overall dimensions, the shape, the appearance. It looks the same. It's just on a larger scale. So you have to change, some of those sub dimensions. So the overall end product looks different. And the actual answer is an ordinary observer test. Is would an ordinary observer or a customer think one is the same as the other, right? Would they be able to equate? And it's a confusion kind of standard almost, like similar.
Yeah, I mean, and then the flip side, the opposite side of the coin for the trademark is that if a viewer saw this individual's box, would they think it came from Apple or whoever the other company X is, right?
Yeah.
If that's the case, then there's a likelihood of confusion between the two, and that's a problem.
Oh man, we hit that one really well.
It
was a good one. I'll
tell you what though, like there's a lot of overlap between trade dress and design patents. They're just
that is an area I'd like to explore further.
Yeah, I mean, trademarks have to get back to source identifying nature, right? So if you have a unique enough package that people come to know or understand that this package comes from Apple, right? This is what they do.
Yeah.
Whether it's like a certain type of box in white with like a matte finish potentially,
yes.
Right? Yeah. They could potentially register that if it's distinctive enough.
Yeah. Let's do another trademark one. We're having fun. This is for international questions. I'm trying to trademark, and it doesn't matter which country it's in.
No, why? Why doesn't it matter which country it's in? It should matter.
Okay, hang in there. That's a funny start. And I'm willing to pay extra to have it accepted faster. So they want it done anywhere in the world as fast as possible. What country accepts trademarks the fastest?
The Caribbean countries.
Which one?
The Caribbean countries.
Ooh, you had an answer. I love this.
Yeah, I've only done it once years ago. But which
can't talk about it. Yeah.
Right. Yeah, which one was it? I bet if you Google around, you can find out which one is pretty quick at turning around trademark registrations.
Okay.
I do know that some of the larger companies, like Apple, for example, will file in foreign jurisdictions, like a country in the Caribbean, and then they'll use that trademark application to hold space until they go to market or want to bring the product to the United States, in which case they'll file a Madrid Protocol application to port the registration from one country to the United States. So it's less obvious to folks who are searching, Apple's upcoming trade dress applications or trademarks to get a sense for what's going on.
Because on the trademark side, it's public right away. Is that true?
Yep, it's public right away. So
everything's
publicly available. Publicly, you can look up what Apple's been filing. Now, of course, that doesn't stop a company like Apple from having subsidiaries who are filing trademarks. In which case, those can potentially funnel up to Apple corporate. But more often than not, they typically file them under their own corporate name, or they file them in a third. If they have like a revolutionary product that they want protection for, need protection for, but don't want to, publicly disclose at this point, sometimes they'll publicly disclose by just putting it in one of these third party countries, like in the Caribbean.
Interesting. Okay.
But yeah, I'm curious why this individual wants to know like how they get the trademark fastest and like what country, because you get trademark rights based on, at least in the United States, based on use. So you have to use it in order to get the registration. It's not always the case in every country in the world. But I'm curious what the motivating factor is here for why they want the trademark registration now. And, an application serial number is not good enough.
Yep. I'm definitely curious too.
Yeah.
Any downside to that? You said some of the bigger companies do that approach where they'll just want to get something
complicated. Typically you're gonna have to hire foreign counsel to, babysit that trademark application. It's easier for us in the United States when we're taking applications abroad, because we can file in the United States and then using the Madrid Protocol international treaty to port applications across the world to member nations.
Okay.
But in this particular case, you probably have to go hire, a foreign counsel in the country to file the trademark on your behalf.
Got it. Very, very good. Awesome.
But I just don't know why they'd want a registration, why they need it, because, I'm thinking from a need perspective, if it's going to be enforced here in the United States, it's going to have to be United States trademark registration.
Okay, well, let's take a few minutes. I mean, what if they are trying to get registration in whatever the Caribbean country is?
Yep.
What's Jamaica, let's say. They would then become a citizen of Jamaica, or have their products sourced out of Jamaica, and then be able to list on Amazon and have a legitimate trademark.
Good question. So Amazon is country by country basis.
Okay.
So if you're looking for Amazon brand registry here in the United States, your British Isles trademark registration is not going to work.
Okay.
It's going to have to be in the United States. And that's kind of where my head was going too, is like, are they trying to get like brand registry in the United States and trying to use like a foreign registration? You can't do that. What you can do is hire a trademark attorney, have him or her file your trademark here in the United States, and then provide the serial application number to Amazon brand registry. And if you have a U.S. application serial number and you have an attorney of record on file, who's obviously a United States attorney, then they will give you Amazon brand registry preemptively.
Ooh,
and then, of course, when the trademark registers, then, it's permanent, essentially.
Yep. Love that.
Yeah.
Love that. Okay. Let's head over to the patent side. We'll do one more for you, and we'll close up our Q&A session. If anybody has any questions out there, I appreciate that like out there. Thank you. We'll take a live question first. So you still have about 10 minutes left. Send over your question. We'll take it. This one came out of Quora. I love it. What are the consequences of accidentally infringing upon a patent while creating a product? And I love the good-hearted nature of this question. Unfortunately, right, whether you did it on purpose, have any intent or not, knowledge or not of an infringement, it is against the law. It's an infringement of that product, and you could be held federally liable for infringing. Now, when you're creating
no criminal liability, right?
No criminal liability, right? But this would be, in terms of civil, the damages, if there are any, the patent holder would be able to enforce their rights. And so you might get a cease and desist letter if this were to happen. And normally, a patent owner, if you haven't had any sales yet, they're probably just looking for a quick injunction, or maybe just allow you to say, "Oh my goodness, I'm so sorry. I'll stop. I'll change my product. I'll stop selling it." That's usually where things end. But usually there's no damages. There's not going to be any, real, threat to moving forward with an action in court. But for, this accidental thing, I'd say the only other thing that might be worthy of attention is if you had a lot of investor money and that was a big accident, maybe you can do business. You can seek a license from the patent holder.
Sure.
If you had a lot of horsepower, a lot of R&D that went into this, and it was a big whoops accident, then you could move forward still with making a product and selling it, but having to pay a royalty, or maybe even buying the patent portfolio from the owner.
Looks like Tom's trying to join.
Tom, all right. Hey, I'm going to send him a note.
Okay. You do that. I'll talk a little bit about what I find interesting about patent and trademark infringement is that, like you just mentioned, actual knowledge of your violation of a trademark, someone else's trademark or patent is not required.
Right.
right? That's a bit different than most standards in American civil and criminal law, right? Generally speaking, you got to know what you're doing is wrong, right, in order to get in trouble. But, we work on this idea that people should have constructive knowledge of your brand or your patent because they filed with the United States Patent and Trademark Office, right? And so that is how you should have known that your trademark use was in violation of somebody else's trademark or their patent for that matter. So I think that's partly the reason why some folks get so upset when they get the cease and desist on the patents or the trademarks is they're like, well, I didn't know. I can't be. It's an accident, right?
Yeah.
It's no excuse, unfortunately.
Thanks for covering that. Okay, Tom, I just sent that off to you. Your unique link to join backstage. Hopefully you get that. Check your email. And that's good. So maybe we'll do one more question for you, Matt.
Sure.
On the trademark side, and that'll give us enough time to bring our guest on for today. Okay. Let's talk sunglasses.
Let's talk sunglasses.
Okay. So you got some sun behind you.
I do. And my wife is in the sunglass business. She owns her and her sister own a couple of Prohibition franchises.
That's lovely. Okay. All right.
Yeah, we're the optical family around here.
Yeah. Well, awesome. Well, okay. This question is a little meaty. So the media company, I found a name I like, but a sunglass company actually has a trademark on the name itself for a pair of sunglasses they carry. I guess my question is, could I use a name but add media to the end without running into the issues? Their name pertains to a product they carry. It's not the company name, and mine would be a company name plus the word media at the end. What do you think?
Very likely you could. Now, if their brand is extremely distinctive, meaning like they made it up, right? It's theirs exclusively. It's not an English word. It's not a translation. It doesn't sound like anything else. It's just made from whole cloth. Then their scope of protection is going to get a little bit wider than it normally would. Okay. So whereas they might have originally been like in the sunglass, class at the USPTO, now all of a sudden maybe they're going to get a little bit broader protection outside of that class because their name is so unique. So again, you'd want an attorney to look at that.
Okay.
Definitely.
Yeah.
But theoretically, you should be okay. Okay.
Got it. Yeah, maybe before Xerox was famous, but the word Xerox is made up. Xerox sunglasses, maybe. Right?
Yeah. And if that's the case, I mean, if it's Xerox isn't a famous brand like Kodak, if it's not famous, I mean, those two are famous. But if they weren't, right, then you potentially would be able to have a sunglass company called that similar thing. Yeah. Unless, of course, this media company kind of plays in the sunglasses world. If they're working with lots of optical companies, they do a lot of marketing work for sunglass companies, then all of a sudden you're really starting to blur those lines.
Okay.
No, that's a unique one. I wish we had like actual examples, right? Then I could like make a,
totally
more nuanced assessment. But
yep. All right, let me try one more time here on this. Trying to get Tom in. There it is. We'll send that out. Okay. Well, we do have a bold bite. We have one other half hour left. Let's stall with one more patent question here.
Okay.
And we'll move to our bold bite. Okay. So this is for natural gas. Well, I've come up with an idea in the natural gas and utility industry that's increased safety benefits, the customer, and reduced risk, operational, and financial benefits for the utility owner. Basically, the idea involves utilizing existing components in an unconventional way to achieve the benefits mentioned. Should I investigate getting a method patent? Thanks for any help. Okay. Let's see. So it's in the utility industry. It increases a bunch of good stuff, right? It definitely has utility.
But it's not a new product. It's maybe like almost like a method of arranging.
Yeah, a business method. To me, this smells like a trade secret. This smells like something you want to keep in-house within your business. You found a way to basically be profitable and to be competitive and make money in this utility industry. Trade secrets cover an enormous body of work. Hey, Tom, sorry to interrupt that. So, Tom, I said check your email, please. All right. Okay, so generally trade secrets, they're going to be kept in house. You control them with employment agreements, and you have to understand, when an employee becomes hired on, you're exchanging money, you're paying them for their time. In that moment, that's the time to get them to also agree to keep confidential anything they learn.
And we call that bargain for exchange.
Yes, contract law, bargain for exchange,
Consideration.
consideration. Thank you. Okay.
That's the Sesame Street word of the day. Consideration.
Consideration. Yeah, because we just say, hey, employee, after they're hired, hey, why don't you sign this, additional form, and you will get you access to the secret sauce. Not as enforceable because they've already you've already given them money for their time to do the work that they're doing. So, oh my gosh, we've got Tom. Look at that. He's backstage. We'll wrap this question up and we're going to get to our guest. So this smells like trade secret. If this is something you think you would want to license out, this business method is just so cool, you want to be able to license it to other utility companies, that's something you get a patent on, so long as it's not going to be reverse engineerable. It's really the other test for trade secrets. So,
JD, can you license a trade secret?
Yes. You can license know-how, and it's the weirdest thing in the world. But yes, there's no requirement for a trade secret to be novel. That's a weird thing. So yeah, you can license know-how. It gets real murky because now you're talking two separate companies, at least 2 times the amount of risk of employees exposing that secret. So many more vendors and contractors. It really puts that trade secret at a really shaky level, shaky ground. But yeah, you can do it. So better get a patent on it. All right, let's bring on Tom Stegeman. Welcome to the show. Tom, you made it.
Hi, guys.
Hey, Tom.
Yeah, I'm not very IT techie, so I'm here.
Oh, you made it. You did great. It's probably my fault. I should have been more clear about what to do here. So I want to put your name in correct. So Tom, is it Stegeman, right?
Yes, it's Stegeman, okay. Stegeman.
Stegeman, okay. And should I put founder, inventor? Do you have a name for this? I should give you a title?
No, just an old guy who came up with an idea.
All right, Mr. Tom Stegeman. Okay, well, you are a Bold client. You've got 2 patent documents sitting behind you. We want to talk about patents.
Yeah, Bold patent got me my design patent first, and we just got our utility patent September 17th. So
congrats.
Yeah, we're rocking. The biggest thing I wanted to share with everyone is we had a very unique way of getting into companies. So once we had this idea and got a hold of Bold Patents and found out that we thought we had a really good idea, we made a prototype, and we probably put this, it's an athletic item. I don't want to get into detail on it, but it has to do with the world of swimming. And I've been a swimmer all my life, and I came up with this just out of the blue. We didn't think it would even work, and it did. As a matter of fact, we had 100% positive results from 100 swimmers that tried it on, everywhere from novice swimmers all the way up to gold medalists in the past Olympics. That are a prototype. We don't have a final product yet. We have licensed it. So the first thing that we decided to do, and my partner Jay and I both are on the patent, we work together because he's the one that had all the technology to make the prototypes. It's the first thing the company, first of all, we looked to see how valuable our idea was. In other words, we knew that we didn't just have an improvement over what was existing. And that's an important key factor, because a lot of these companies don't just want another way to strap something on or this or that, because they've already got their product line. They really don't want to retool for something. We had something so unique, we called it revolutionary. I mean, that we were that bold with it, and it really, what we did really was ultimately. The next thing we did, what I want to get to is how we got into these companies. So we listed the companies in the swimming world that produce swimming products, and we went 1 to 7. We went from the biggest ones we knew, and you saw them all on the caps at the Olympics. You know, everybody was sponsored by. we actually went with number 4. I'm going to skip ahead. I'm going to tell you, we went with our 4th choice because they weren't real big, but they were in the United States. They had a good reputation for innovative stuff, but we wanted to go big, just like everybody else did. So what we did while we were doing the prototype and really getting our act together, instead of a spreadsheet, we decided to go ahead and do a video.
Okay.
To actually show this item. And that is one key thing that I would like to emphasize with anyone who's making a physical product. Because when we started trying to get into these companies, they really wanted to know if we've tested it. Do we have a prototype? How many people have we tried it on? They even wanted to know if we did a market study. Well, we don't know how much it would cost to produce, the injection molds and all that. So we were honest about that. And that wasn't a major thing. They were more concerned about the reaction to what we had done. Okay. So we had everything really ready to go. Okay. So now we've got 1 through 7 that we're going to contact.
Real quickly, Tom.
Yeah.
How hard was it to get 1 through 7 on the phone or get a meeting with decision makers?
Well, initially it's very hard. So my next point is make sure you take notes. Take notes on your research of the companies. We found companies that had already been bought and sold 3 times in the past 2 years. They're in financial trouble. You're going to find a lot out by researching reviews on companies. That's number 1. You're going to learn a lot. So when we try to approach these companies, you're going to get on the phone. You're going to get the customer service. Michelle's on the phone. And you're going to tell her that you would like to speak to your new product development guy or girl or team.
Yep.
And she's going to say, well, we have a portal on our website that you can submit your idea. Well, first of all, you don't have an NDA in place. So you're not just going to spill your guts on this thing. Okay.
Yes.
But this is why it's important to take notes. Because you might find out who this person is that you need to contact. So let's say his name is John Dingledine. Don't ask me where I came up with that.
I hate that guy.
So you got his name. So next time you call Michelle, you say, hey, can I speak to John D in product? She goes, may I say who's calling? You say Tom Stegeman, figuring they know, and so you got John. Now that's still kind of rare. The thing is, you got to be patient and persistent. They don't want a phone call every single day. Okay. But here's what we did. Because we were testing our swim product on so many swimmers, we were in contact with coaches. We were in contact with, so we went to a pool and the coach knew somebody that represented them. One of the companies that actually gave them team gear. And he called the company for us and said, hey guys, you got to check this out. These guys came up with something really cool. Okay. So that's how we got into one company. Another company was, the other little trick I did, and I probably shouldn't emphasize this because this could backfire on you. Let's say it's John Dingledine and you're not getting into John.
That's not what JD stands for, by the way. I'm not John Dingledine, just so you guys know. Okay.
Oh, that's right. Oh, I didn't think about that.
That's all good.
All right. So if you know that you know at such and such company.com, all you have to do is get his name in front of it. So it's either JD with periods or it's just, in other words, you got it. If you know someone else in the company, you can figure out how to do him and you can get right into him. Now that may sound sneaky, but I don't think it is. Now, the other thing you've got to get prepared, whether you talk to somebody on the phone or you finally get an email from this guy, you need to have your 1-minute spiel ready. They don't want a lengthy, this thing is great, They want, so when we called, we said, hey, we've got a revolutionary new swim blank. And we've tested it on 100 swimmers with 100% positive results. They all want to buy one. And we think you ought to look at it. We think it would be something that you'd be interested in. And that's pretty much how we got into these companies. So then, the next step is to get your NDA in place. They say, yeah, where do we go from here? Can you send us one? Sure. Can you send us a CAD drawing? Sure. But we had a video. We said, let's set up a video Zoom meeting where you can meet me and my partner, Jay. You can see the video. It'll explain everything, and we can go from there. Now, what we found out with the NDAs was very important, and I'm sure you guys have been through this. You can learn a lot about a company's attitude from their NDA. I mean, we had one major company that mostly is in basketball and baseball, but they did have some swim products. They basically said, if we send it in to us, send the NDA back, and if we like it, we'll give you fair compensation for it. We're like, whoa. We had another company that, so that was company number 5. Number 3 actually sent us a 9-page NDA. I don't know how many attorneys they had on their staff. And it was, you can't sue us for any more than $50,000.
If they breach.
If they infringe. We're like,
wow.
ding. And what's interesting, you can find a lot about NDAs. So I suggest, and I know you guys probably do too, you want them to send you theirs first so that you can review. And you're going to get a lot of attitude just in the way they sent you the NDA and the way they talk to you on the phone. That's very interesting. Okay, so we kind of Frankensteined our own NDA if they asked us to send one. We did a pretty simple one, pretty good one.
You didn't do this on your own, right, Tom? You got a business attorney to help you.
Well, we should have. This is the only, JD, this is the only time that we did good with it, but it's the only time that we did not get professional help throughout the whole process, from using you guys, which was awesome, to our final licensing agreement. We got a contract attorney. So yeah.
Good.
So anyway, we have our NDAs in place. We showed them the product. The other thing is keep taking notes, because you're going to learn so much. You got to get names of people. You're going to be meeting different people. And so we wound up with number 4. It was very interesting. One group, they were home base in Italy, and they were a very major swim outfit supplier. And their NDA, they actually said, if we have litigation, you have to come to Italy. So that we got over that, because we want it where we live, and they took care of that. But we were still nervous about how big they were and the fact they weren't in the country. And I think that's a very important consideration to make. And so the approaches we took were very, very slow and methodical. But there are ways. I guess what I'm recommending is see if there's another way to get into the company through a third party, like my example of the coach that I used. I also had another coach. There's magazines on any topic. Okay, you pick any topic. There's a monthly magazine or bi-monthly, or there's a website that everybody looks at for that sport, triathlete, baseball, whatever. So we knew somebody that knew an editor of this particular site and magazine, and they called for us and said, "Hey, you ought to check this thing out." And that person actually, we told him when he called me, I said, "We can't get into this number 1 company. We can't get in." And he said, "I'll get you in." I had a good recommendation from, University of Florida coach, let's say. And he said to check it out. So I would suggest, if you're real serious about how good your item is, that you do due diligence on prototype, presentation, if you can, by video. You get your 1-minute spiel ready, because that's all you're going to have with somebody once you get them. And then go from there. And the other patient part is, we didn't talk a lot about, they wanted to see our attitude, and we wanted to see their attitude. It was very, It was like, eventually you're going to get married. And when we got frustrated, Jay and I thought, well, let's make it ourselves. Let's just make it ourselves. Well, we don't know what we're doing. We're in retirement age. And finally I said, Jay, you know what? We don't know the market. We don't know how to make it. I mean, we probably could figure it out, but let's say we can sell 10,000 units and profit $12. That's $120,000, which is ridiculous. We know it. That's still unreal, probably. Where we take it to somebody and they're saying, hey, we're going to make 100,000 of these in the first year and take $3 or $2. I mean, do the math, $20,000 and you're not doing anything. They've got all the markets. They know how to do all the international stuff. They've been through infringement lawsuits before, and they know how to.
The audience here on edge. Swim cap, mask, flippers. Are you under NDA? Can you not discuss the actual invention?
I'm gonna show it to you.
I did look up the patent because I was curious too, Jonathan. And
what is it?
It is cool. Yes.
I know it is.
My daughter's a competitive swimmer. So
JD, that's what everybody says when I walk on the pool deck. They go, "What is it?"
Yeah.
Okay, your foot goes in here, and it only goes past the ball of your foot and stops. It's soft silicone. My partner Jay and I, we thought, there's no way this is going to stay on your foot. Like you put a sock on the end of your foot and it flips off. Well, think of the torque in the water. We didn't think it would work. But I grew up with Jay. He was my college roommate. He does 3D printing and laser technology. His son swam for Purdue and said, Dad, that's not going to work. Anyway, he made 2 pair, put them on his feet, went in his backyard pool, and he called me. And we were calling each other Orville and Wilbur, by the way. We had fun doing that. So he says, Wilbur, not only I can't get it off. And I go, what? He says, I can't get it off. I go, what are you talking about? Well, when you put it on in the water and you squeeze the water out, it sucks on your foot. So physics is our friend.
Yeah.
And JD, your patent guy that got us both patents, Randy
Fenton, yeah, Randy.
He said, and he was a swimmer. He goes, guys, this is one of the stupidest, simplest things I've ever seen. Because it's one piece, it's half the size. So, yeah.
Very cool. So it's a swim fin. Can we say
now,
that?
So my other point on this, because we look, you really do have to analyze. I mean, everybody who invents something thinks they've got Velcro. I mean, it's just, it's part of the ego. And I admire anybody that's being creative. But we lucked out that we really had something that was unique that nobody thought of. I mean, nobody had thought of this and why it would even work. Most people are doing an alternative to what's already out there. And a lot of these companies are just, they've got people on staff that are supposed to be thinking of a better way to put something on or do something. And so when we got all done with the licensing and we talked to the owners and everything, when all the cards were on the table and we had signed the deal, I said, let me ask you something. First of all, why did you give us a shot? And he said, because you said revolutionary, and you had tests, you had a video, you had already done so much data that was important. I said, okay, my second question is, how many people contact you with the next greatest thing? And I thought that was interesting. He goes, about 1 or 2 a week. So maybe 50, 60, 80 throughout. I go, really? I wouldn't think it was that much. He goes, oh, we're getting calls for better way to put goggles on. And, so I thought that was interesting at how many phone calls they do get. And he said, but you never know if there's a diamond in the rough either. So you got to give everybody that 1-minute phone call.
That's awesome. Tom, thank you so much for sharing that story.
Great advice. Really great advice, Tom.
Yeah, it's solid. We're going to have you back. Love to have some more details about how things are going. if you're one.
Yeah, I would be curious to learn more about the actual licensing agreement, how it's structured. If it's
well, that's another thing. Yeah, that's something else I want to share in how much you can push for your end of it. And this was a good example because the owners were actually a brother team. And, the bean counter always wants to give you $1. And the guys that really want it because they know how much they're going to make want to give you $3 or $4. So it was very interesting how it went.
Yeah. Okay, I think we're gonna do a part 2. We're gonna budget a little more time. I do want you to stay on for our Bold Bite. We do a Shark Tank critique, and I did find a swim product, so I think it's the same category. Certainly far from being the same type of thing. So I'll keep you on for that. I'll put you backstage and bring you back on for comments. So thank you, Tom. Hang on. All right, let's get that pulled up. That was cool, Matt. I'm so glad we got Tom to share some of that.
Yeah, it was cool. I was enjoying reading through his patent.
Good. I'm glad you found it. Good for you for finding it. Okay, I'm going to switch over our audio. Here we go. The tandem boogie. Can you hear that?
Sounds descriptive to me. I don't hear anything yet. Try again. Yep, we're good.
All right.
Into the Tank is a company that believes 2 is better than 1.
I'm Manya.
I'm John.
I'm Juju.
I'm Lila. I'm Aliana. And this is Tandem Boogie. We are from San Clemente, California.
And we're seeking $100,000 in exchange for 10% equity in our company. Our family has always loved going to the beach together, but we wanted to catch waves on the same board. So we created the Tandem Boogie.
On the Tandem Boogie, every wave is a party wave. Take a look. You can catch a wave with anyone, whether you're a child going into the ocean for the very first time, an adult that's been intimidated by the waves, or a teenager that just wants to try something new. The Tandem Boogie is for you. You can surf it, you can ride it front and back, or side by side. It takes 2.
Now that's family fun. Our patent-pending dynamic air design allows us to make a board this big fit into a bag that small. You just show up at the beach, you pump it up, and then you've got a board with handles and a camera mount so you can capture all of the action and those memories that will last forever. So, Sharks, who wants to join our Tandem Boogie family and help us bring the fun to everyone?
Now, we want to ask Robert if you'd like to come and actually try catching a wave.
Hi.
All right.
Sure. Let me try. How do you pump as well?
Yes, we provide the pump as well.
So just grab onto the handles. You can hold on to the ones. Like you're catching a wave.
If I had my little one, he would be here or she.
Yeah.
And then I would hang on.
Right. Yeah.
You can do 2 people side by side too.
Yes, 2 people.
Adults.
Yep, we go side by side. We're side by side in the video as well.
It's super fun. Like it feels very solid.
Wow. So you guys are this great family. I'm just curious, who's running the business? What's the story?
Well, we each have our function. I'm in charge of manufacturing, operations, logistics, the website.
And I'm in charge of marketing and sales and social media.
And I'm the CFO, which stands for Chief Fun Officer. I make sure that our brand stays in line with our vision, and I'm the creative director.
I'm in charge of the merchandising. I'm in charge of community outreach, and then also making sure everybody gets the job done. I'm the oldest sister.
I just love your unity. Did you consciously design something that you could involve your daughters in?
We had, as a family, growing up in San Clemente, California, we had participated in so many different water activities. There's actually a picture of us, all 5 of us, on one stand-up paddleboard.
Oh my gosh, that's the cutest thing ever.
It's all you need. Throw it in the back of your scooter, your bike, take it to the beach.
Exactly.
That's the selling proposition to me, because there are other products like this. But
You're such a killjoy.
So what is unique about our product? We call it dynamic air design because the design is what we've perfected.
But has anybody else done this?
done this exact thing? No.
So we designed the board, and then we consulted with our attorney, and we did file for a patent, a utility patent on this design. It has been submitted. And that's for the whole design, incorporating the handles, the locations, as well as the camera mount.
Who goes out selling, or is it only online? How's the whole sales process work?
Well, it's been a bit different this year due to the pandemic. So we had to pivot towards selling online. And what we actually ended up doing was we launched a Kickstarter campaign as our first way of selling. So we did that for 1 month, and we've done $43,000 in sales.
Was that all on Kickstarter? Your
31,000 was from the Kickstarter, and that was between June and July
of this year.
Yeah.
Oh, you're brand new.
We're brand new.
brand new.
Oh, you're brand new.
Oh, okay.
This boogie board is $59, $69, $79, depending on size, under 100 for sure. Are you getting a lot of pushback?
Shark, would you like to have a tandem boogie partner from the panel?
Well, there's only one other shark left. It's Daniel.
Daniel, what do you think?
I'll tell you my thoughts on this. I love you guys. This is a sport that my family enjoys. My wife loves this stuff. My kids love this stuff. I'm kind of the loser in the family that's bad at it. I have online expertise. We sell over $100 million online. If Robert would like me to come in on this to provide support, I think we could do it for 25% for the two of us.
25% isn't enough. I'm
Robert? Daniel?
You can join our Tandem Boogie family.
All right. They did a deal. They got investors.
Oof. Hey, before we get too far,
Yeah,
Katie, I got a dad joke for you.
please.
You might have heard this one. How do you make a tissue dance?
Put a little boogie in it.
Put a little boogie in it.
Ooh.
All right.
I was all over that, dude.
Yeah,
Love
you
it.
were.
Thank you. That's
You're
great.
you're a dad. You get it.
Yeah, we're dads.
You
Tom,
know-
what are your thoughts?
Well, they showed a video. I would like to see, they need to separate their testing by a kid underneath dad or mom, two adults. Their video was very fast, and they did a lot of talking about this works. I saw a lot of adults that weren't even on the board. They were behind in the water. I'm just saying that I tell you what, these companies that we dealt with, you saw what we came up with. And as soon as I explained it, you went, whoa, that's very unique. And it really was stupid luck that we thought of it in some ways. But I tell you what, these companies are ruthless they're going to probably want all 5 sizes in their place with an NDA to test them themselves. And that's how serious it is when you're talking units of 100,000, and to analyze the market to see what else is on there. I'm a little surprised you can get a utility patent on something like that, other than it's a blow up. That could be what the kicker is on that one.
Yeah,
But
I've got the patent pulled up. They did get it issued eventually. It did take them a couple of years. I'll share this briefly. We'll have about 5 minutes left.
Okay. I'm not saying that they couldn't. I'm just saying that doesn't surprise me that it would take a while.
Well, I think the points of novelty is great. So it does take a lot. So to get this, the first utility claim, it's inflatable tandem surfboard comprising, it's got 7 different elements. A base that's cut into a shape, a base fabric layer, right, applied over the secure top side, an intermediate portion, which has an air chamber, upper layer, a deck pad layer, and then they've got these rail layers and a second rail. So you really a lot of detail. And in general, the more detail you have in a patent, that means the lower, the decrease in terms of your scope of protection. Because
I remember that. Yeah, but sometimes you have to do that to show you the uniqueness of it.
Well, what that means is they had some prior art. And I think that Sharks pointed that out, that there were some other products on the market.
I don't know. And, the other thing I know about that I've heard about Shark Tank is the deals that are up front. I mean, first of all, it's a show. When they go back in the green room, or they get, your people talk to my people, sometimes the deal doesn't go through because it's not all, there's not enough information to really make a deal in 5 minutes. And my immediate response to that is, they're showing 2 people on it. I don't see 2 people. I mean, I'm 6'4", 240 pounds. I don't think anybody else is sharing my boogie board. By the way, our fins are prime for boogie board people. Think about it.
Yeah. Hey, that's great. That's a good point. They go hand in hand. Dare I say?
No, but you know what? I love analyzing these things from what we went through. But my whole point is, even if they went with a Shark Tank person and got it, there's a lot to manufacturing and getting that thing out on the market. I mean, I have found that sometimes the most successful thing to do is to go with a company that's already leading in a particular field. Like for baseball, Rollins or, Voigt or whatever it is, Nike, And by the way, Nike was the one that had the worst DNA or NDA. I mean, it was just.
I've dealt with them in the past.
Have you, Matt? Yeah. I'm just saying that's a good idea what they came up with, especially what Kevin said about the roll up and the inflatable. That is. I mean, you see people putting surfboards on their cars.
Yeah.
So my 2 cents is it's a good idea. I think it should be longer. I don't know that they have the design down exactly perfect.
Right. Yeah. That's a good point. Matt, do you have anything to mention on the trademark side?
Yeah, not a great name from a registration perspective. Tandem Boogie is pretty darn descriptive of what the product is and who it's meant to function for, right? So it's tandem, 2-person, boogie, boogie board, which is cool. What's that?
They did rebrand. I checked up their update. So TANDM. So tandem, if you can see my screen here.
They spelled it different. Right?
Yeah, T-Andia. So they went to this mode. It's a little different. So
I can't see your screen, JD. Here, hold on.
Okay, let's see if I switch it over here. Are you able to see that?
Yep.
T-A-N-D-M.
Tandem.
Yeah. Tandem.
Oh, is that a D? T-A-N-D-M?
Right. Maybe because of that trademark issue.
Maybe so. I mean, even then, the USPTO could say it sounds similar to tandem, and it's still descriptive, still merely descriptive. And I don't subscribe to the view that good marketing is intentional misspellings of words. That's just
Matt. Am I incorrect? It's not totally necessary to have the trademark. Sometimes if you have a product and you just kick butt with it and it just goes out there. Like we were going to call our fin Flex Fin, which you can't do because it's 2 words that are common.
Descriptive.
And there already was one out there, but I know a lot of products, they don't trademark them. They just go for it,
I mean, there's no trademark police out there that are going to say you have to have a trademark registration. But if you want to enforce the trademark, if you want to license the brand, if you want to sell the brand,
come up with something,
owner, customer,
come up with something unique. Yeah.
Come up with something unique. If you want to sell on Amazon and participate in Amazon's brand registry, you got to have a trademark application or registration. So,
and I bet the company you licensed to, you may not be willing to share, Tom, they're going to be coming up with a product name for it.
Well, it's actually Finis, and they had now TYR Speedo is really the one that's in trouble, but TYR Arena had most of the Olympic. TYR actually had all the big parkas, and they put the most money in and got the sponsorship. Finis actually went to Great Britain and Australia. They had the logo that kind of looked like a kangaroo, but it wasn't. It was a wave. But they had 4 gold medalists, 3 silver, and 2 bronze. Wow. And we actually had our prototype fins on Summer McIntosh from Canada that got 3 gold, and she beat Katie. She came in second behind the Australian, beat Katie Ledecky in the 400. And Summer's up in Sarasota, and she was the first person one of the first people I put my prototypes on. And after swimming several laps, she said, "I love these things." So when you start getting that, take notes, because when you talk to a company and you tell them that Summer McIntosh was training with these, in other words, there's so many second avenues that you should take. And a lot of it's preparation. Don't just think you're going to start calling companies. Why not take some time and really do our prototype? Our first prototype was working, and then we put it on this really big college guy, and one of them came off. And so I called Jay and I said, Orville, Wilbur, don't sell the bike shop yet.
Right. Well, you're still fine tuning it. Tom, at the end of our session, thank you so much for your time. I will have you back on if you're willing to share some more updates with how things are going with your swim fin.
I would like to, and this is probably more, I don't, Matt's into trademark, but I tell you what, the whole licensing process for us was really a lot of verbal, a lot of communication, a lot of give and take, but nobody got, it was really an interesting process. And that took about 4 months total. Right. There was a lot to discuss and to look. So, yeah.
Let's have you back to talk about that. What happened in those 4 months? I'd like to know. That'd be great.
All right.
Thanks, Tom. Thank you, Matt. And for all of us.
Nice to meet you, Matt.
Wish you guys a good week. Have a good day, everybody. Go big, go bold.
Go big, go bold at boldip.com.